Mr. Gonzalez, I need you to identify yourself, and I need you on camera at this time so you can tell me who you are so we can proceed going forward.
All right, are we on record?
Yes, you heard me say I'm recording it on my digital recorder. That's my official record, and we're live streaming on YouTube, so it's being recorded there too. And I'm going to explain all that in a minute, but first of all, I need to identify you as parties. So if you can show your face in the screen, and then Mr. Calvano, would you oppose Mr. Gonzalez appearing after he shows himself and announces himself? Is there any reason he needs to be on video?
No, no objection, Your Honor.
Ms. Solis, are you okay if we stop the video on him during this hearing?
That's fine.
That's fine, but I just want you to identify him or to see his face and know that it's him for the record. Mr. Gonzalez, one time, show your face, tell me who you are, and then you can stop video.
All right. Without my consent, I'm doing this just to let everybody know on the record.
Okay. And give your name.
Gerald Gonzalez.
Ms. Solis, was that Mr. Gerald Gonzalez, the non-custodial parent in your case?
Yes, ma'am.
Okay, then you can stop your video. You can show the roof ceiling, whatever you want now, Mr. Gonzalez. Ms. Solis, go ahead and identify yourself.
Isabel Solis.
Okay, now I need to swear you both in. I need you to raise your right hands. Mr. Gonzalez, I can't see you, so you have to tell me when your right hand is raised for the record. Mr. Gonzalez, is your right hand raised, sir?
Yeah, it's raised.
Thank you. Do each of you swear to tell the truth, the whole truth, and nothing but the truth? Starting with you, sir.
Yeah.
Ms. Solis?
Yes, ma'am.
Thank you. Before we start with Mr. Calvano and the background on this case, I need to tell you a couple of things. Whether you heard them before or not, doesn't matter to me. I'm going to restate them so you remember. One is that I'm an associate judge. I've been appointed to hear cases filed by the Office of the Attorney General, the Child Support Unit. So as an associate judge, they don't give us court reporters. I have a digital recorder. That's the official record that I get to keep. So Mr. Calvano, you're prosecuting this case. I assume you'll go ahead and announce yourself and give me some background on this matter.
Yes, Judge. Thank you, Corey Calvano, for the Attorney General's office. Judge, this case was filed as a suit for modification of support order and a motion to confirm the support arrearages. It was filed in the District Court of Guadalupe County on April 16th, 2024. Mr. Gerald Gonzalez was served by citation in this case on the 10th day of June 2024 at 3:18 p.m. at an address in San Antonio, and that was signed by Deputy K. Bamert, number 331, the Sheriff's County Office. Additionally, the parties appeared in this case on, it looks like, the 10th day of September 2024. I don't see that Mr. Gonzalez signed the reset, but I do believe that he was present and that there might even have been a hearing in this matter, and the case was reset to today.
Okay, and then any opening statement with respect to the state's position on the issues before this court?
Yes, Judge. Judge, this is a modification of a final decree of divorce. It looks like it was possibly a pro se divorce decree that was done on January 31st, 2019. The obligations that were established in that divorce decree were child support in the amount of $340 per month. And medical support was set. There was no medical support set. Mr. Gerald Gonzalez was the person ordered to provide medical insurance through his employer. The modification request here today is to confirm the arrears in this case. And the arrears as of September 30th are $5,165.61. And to modify child support to right size it based off of the current income information of Mr. Gonzalez. Mm-hmm. And finally, to request that Ms. Solis be the person ordered to carry the health insurance at a reasonable cost and the dental insurance at a reasonable cost through her employer.
Okay.
Unfortunately, sorry, Judge. Unfortunately, at this time, I am unable to determine whether or not it's at the insurance is at a reasonable cost, as I've not been able to get income information from Mr. Gonzalez.
Okay, but that would be mother's burden to show what it cost, and then
That's correct, Judge.
there is a cap that we can't go beyond, so okay, I get it. So Ms. Solis, Mr. Gonzalez, there's been a lawsuit filed by the state. Y'all are parties in this lawsuit. You've been noticed to come to court and noticed about the lawsuit, so that's what the law requires. Mr. Gonzalez, you have said over and over that off record and now on record that you do not consent to be here. It doesn't require your consent. It's a civil matter.
does.
So you can choose to be here, and you've been noticed to be here. All the legal requirements have been met, so we can go forward and you can participate, sir. And you do have to follow some rules here. It's not your court, it's my court, and I get to make the rules, and I get to have you all follow the rules. And if you don't, there are consequences for that. Now, if you choose not to be here, you choose to log off, I just need to warn you ahead of time that you could be defaulted, which means you're noticed about this, you know about this, you're here now. And if you choose to log off and not participate, the default means we go forward without you, and whatever consequences are of that, they happen because you didn't bother to stick around and finish it off or tell your side of the case. So it doesn't require your consent. It requires your participation in a civil matter if you choose to do so. And a lot of people choose not to come to court and they get defaulted. So that would happen to you if you chose to leave. Let me stop real quick. Miss Ashley Leha, you're in my courtroom. I'm having a hearing. Do you need to be somewhere else? Or State, do you need to move or somewhere else?
I was waiting on the thing and I'm not really sure what was happening.
Okay, thank you,
It
ma'am.
said I was in the holding room.
State, do you know what needs to happen to Miss Lehan? Move to another room or so?
I can move her to a room, Judge.
Thank you, Miss Oweda.
Yes, ma'am.
I didn't want to have her sit here and listen to all this if it wasn't necessary.
Yes, ma'am.
Okay, Ms. Leha's out of the courtroom now. So what I was saying is your parties, you're here, it's a civil matter, nobody goes to jail. That's not what happens in the civil case. It's a question of how much is owed in back pay for or arrears for child support that was ordered and not paid, how it's going to be paid off. And the second part is whether a modification should be granted. And haven't heard anything yet about whether child support should go up or down in this case, but that's what the modification means, that the last order can be modified or changed for child support to be higher if there's a different income and it's higher, or lower if that's the proof that's given. So again, notice has been given. We are allowed to proceed, and Mr. Gonzalez, your consent is not required.
It's
Please,
required.
do you have any questions or concerns about anything I said yet on these issues? Ms. Solis? You have any
No,
questions?
ma'am.
Mr. Gonzalez, do you have anything else to say before I let the state call witnesses and then you get to answer questions?
My consent is required because just letting you know that. And that's it. But no.
If you want to point me to a specific statute or tell me what law tells you that you get
my
to
right
consent.
my right to live, my right to choose free will.
Okay. Your right to live, nobody's taking away your
You're
life.
trying to by saying that I need your consent. That's me being forced into your courtroom right now.
Well, what do you
As
think courts are? They're where people bring disputes and disputes
Right,
about,
well,
you
people,
have
which means
different
dis-
sides
disputes
of an
between
opinion on an
me
issue.
and
So
me
you've been
and my
given,
person, not
hold
you.
on, Mr. Let me talk now. You already told me what you said. I'm trying to address it. You don't have the right to consent to what the court does. You have the right to be here and participate. And we're not taking your life away. We're not taking your civil liberties away. You're not going to be locked up in jail. The question is, how much should your child support be to pay for your children? How much should the insurance be to reimburse Ms. Solis? And those are matters that if you all cannot negotiate and agree, then this court has jurisdiction to decide the issue. And then it doesn't mean that you get to say, okay, I agree with you, judge, or no, I don't agree. If you don't agree with the judge's decision at the end of the trial, then you get the right of appeal. So you can go to a higher court and take it to them and see if I did the right thing or not. But you have a venue of appeal. That's your rights, Mr. Gonzalez, and so I've told you that. So now state, you can call witnesses. The state's going to call witnesses one at a time. That would be you, Ms. Solis, or you, Mr. Gonzalez. They get to decide who goes first. Then the person who's testifying, you have the floor. You get to answer questions. At the end of the questioning period, then I will ask you if there are anything else that you weren't asked about that on the relevant to the issues, and you'll get to give a little bit on your side without the question and answer form. But during that time, the other party needs not to interrupt, needs not to make it about them. It's not about you. It's the person who's testifying that has the floor. And unless you have a solid legal objection to whatever's going on at the time, you don't have the right to interrupt. And then when it's your turn, you'll be given the same courtesy. That's how it works. So Mr. Calvano, you pick your first witness and we'll go from there.
Thank you, Judge. I'll call Gerald Gonzalez. Sir, will you state your full, unmute please, and state your full name one more time?
Gerald Gonzalez.
And are you the father of Jace Isaac Gonzalez, born November 19th, 2014?
I hope so, yes.
Did you enter a final decree of divorce on January 31st, 2019?
I don't know. I would assume yes. That's what I'm saying. Like, I wasn't told anything. I was just forced to sign this paper. So without my willingness or consent or knowledge of what's going on, which is, not an actual contract, by the way.
So you did not sign the final decree of divorce?
No, I signed it, but I signed it under pressure, under duress, under distress, under people like throwing it all over my face, and without full knowledge or consent of what's going on.
Okay. And in that final decree of divorce, you were ordered to pay child support of $340 per month. Is that correct?
Yeah.
At some point, you got behind in your child support. Would you like to tell the court why?
I didn't have a job for like a year and a half, and somehow you guys took out of 10% of zero.
What do you mean we took out 10% of zero?
There's no income. You can't take out of nothing. You're charging me money if I had nothing to give.
Do you agree that you were still under the court order at the time you were unemployed?
I was never under the court order if I was forced under this contract unwillingly.
Okay. Are you currently employed?
Yep.
Where are you working?
Why?
Because I'm asking, okay, if you don't want to answer that, how much do you make per hour?
Why?
Okay, Mr. Gonzalez, the issues before the court is whether your child support is the right number or not. So this is your opportunity to tell us what your actual, hold on, let me finish. It's my turn. Let me finish. It's your turn to tell us by answering questions how much you're making so we can decide whether the 340 is too high or too low, because your child is entitled to that and the law allows it.
The same way it was. Just
I'm not asking a question, so I don't know what that answer was for. So wait till you go back to Mr. Calvano and he asks the question again. But I'm telling you that it's relevant, it's appropriate, and again, you're arguing things that are irrelevant. That you signed an order and you think you're under duress. The only way to undo it is take it to another court at a higher level to try to undo it, and that has not happened. So it's a valid court order. So I'm required to look at it and to modify it if necessary. But the only way I can modify it and for it to be in your benefit would be for you to prove what your income is and for me to decide that is higher or lower than the last time and whether or not I can go up or down. So you can cooperate with us or you can choose not to cooperate. But either way, this is happening today, whether you like it or not. And it's not a contract. I have jurisdiction over you and over this case by virtue of the laws of this state and the court having brought this lawsuit and you being on proper notice of it. So either you answer questions and figure it out with the actual information, or I'll figure something else out, because we're going forward today on the state's issues. And you can't keep interrupting. You can't keep telling us we don't have jurisdiction because you don't consent. That's not the way it works. I have jurisdiction whether you consent or not. If you don't agree with my ruling at the end of this, you can appeal me. That's what your rights are. Mr. Calvano, ask your question again.
How much money do you make, Mr. Gonzalez, on an hourly basis? I'll withdraw the question. Mr. Gonzalez, do you have health insurance through your employer?
Not yet. I'm waiting to get hired on to the company.
Are you currently employed?
Yes.
Can you explain how you're waiting to get hired if you're
Uh,
currently employed?
So I'm on a temp agency, and I've been working there already for like 8 months or whatever, but I haven't been hired on to the actual company. So that's where all the benefits are, I guess you can say.
Okay, that makes sense. What is your hourly rate working through the temp agency at that employer?
Didn't you withdraw that question earlier?
And I'm asking it again.
Oh, you
I have-
already like I don't understand because you guys are already taking out for it. So like,
I have no
What's
further
the problem?
questions for Mr. Gonzalez, Your Honor. I'd like to call Edna Garcia, if Your Honor would allow.
Yes, let's move on. Ms. Garcia can be a witness. However, if I'll need her to identify herself and also swear in, I don't think I've done that yet. So we can call her.
Correct, Your
Ms. Edna Garcia, you're now on the screen. You're appearing in my virtual court. Go ahead and announce yourself with your full legal name, ma'am,
Edna Garcia,
and your occupation
Child Support Officer
with the agency.
with the Attorney General Child Support Division.
Okay, thank you, ma'am. If you'd raise your right hand so I can swear you in. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. Mr. Calvano, your witness.
Thank you, Your Honor. Miss Edna Garcia, who do you work for?
With the Child Support Division, Attorney General.
And what is your job title?
Child Support Officer.
And in your duties as a child support officer, do you have the need to look up income information for the customers of the Attorney General's office?
Yes,
And did you do that in the case of Mr. Gerald Gonzalez?
I did.
And can you tell the court what the most recent income information was for, and what quarter that was for?
Okay, so the most recent for the second quarter of 2024 was with a temp agency for $11,563.08 for the 3 months.
And if that was the second quarter of 2024, can you tell me what the first quarter of 2024 was?
Yes. So for the first quarter was $5,423.10. And that usually reports when it's a partial quarter.
Okay. And then were those the only two reportings for the temp agency?
Yes, for this specific one.
And what were the reportings prior to that? What was, in other words, what was the fourth quarter of 2023?
So for the fourth quarter 2023, he was with Whataburger Restaurants and he earned $2,157.90 for the fourth quarter of 23.
So in situations where we have such a disparity of income, is it normal then for the Attorney General's office to use only the current and for figuring out a monthly average?
Yes.
I have no further questions from Ms. Garcia, Your Honor.
Okay, technically, Mr. Gonzalez and Ms. Solis, you all are parties here, but you're also acting as your own lawyers, and lawyers have the right of cross-examination of any witnesses brought before the court. So, Mr. Gonzalez, Ms. Solis, I'm going to give you your opportunity to cross-examine Ms. Garcia if you have any questions. Let's start with you, Ms. Solis. Do you have any questions for Ms. Garcia at this time?
No, I don't think so.
Okay, thank you, ma'am. Mr. Gonzalez, do you have any cross-examination questions for Ms. Garcia at this time?
Yeah. So, who are you and what do you do?
My name's Edna Garcia. I'm a child support officer with the Attorney General Child Support Division.
And what do you do?
I draft orders, I do locates for customers, and assist the attorneys with their legal actions.
Okay. And like, so you were able to look up my income all this time, is what you're saying?
Right, I was able to look up your income.
So whenever I had zero income, did you look that up?
You currently do not have zero income now.
Yeah. But when I did have zero income, did you look that up?
I probably can. Let me see if you have any periods where you didn't report anything.
Judge, I'm going to object to this question.
No, you can't.
Okay, first of all, Mr. Gonzalez, Mr. Calvano didn't even get to say his objections, or you get
I
to
already know what
wait.
you're gonna say.
I get to hear the objection. I get to hear your objection to the objection, then I get to decide if it's relevant or not relevant. So, Mr. Calvano, you want to object and finish your statement then?
Judge, the objection is that this question is irrelevant. Ms. Garcia, it has no obligation or duty to look up every person that is ordered under child support in the state of Texas and see if their income has changed. The only reason Ms. Garcia would have any reason to look up information is if there is a lawsuit filed, and there was no lawsuit filed at the time Mr. Gonzalez's income was zero. Therefore, under relevance, the Attorney General is objecting.
Okay, and Mr. Gonzalez, you want to finish your statement then?
Yeah, that makes no sense. I've been under this lawsuit or whatever. I've been paying child support this whole time since, I don't know, my kid was, 3, I guess. So I don't know what he's talking about. I didn't know there was a time where I didn't have a child support case. So I don't know what he's talking about. Secondly, if she's able to do it, she's able to do it. So just like he did it just for her, he can do it for me. So, or whatever, vice versa.
Mr. Calvano, I understand your objection. I get that we're not trying to prove or go back and modify to zero because I don't have that authority. However, I'm going to give some leeway to Mr. Gonzalez since he's pro se and he has a right of appeal anyway. So, Ms. Garcia, make it my question, and I consider it relevant. Can you go back as far back as your record allows and start from there and just tell me what Mr. Gonzalez's history? Not that it's going to be used for current income, just for Mr. Gonzalez's sake, so he knows that the state has his income correct now. Okay.
Okay, so we can go back to the fourth quarter of 2007. But that's, I believe, prior to the, so is that too far?
That's way too
Yeah,
far.
just
Okay,
like the past 2 years.
Which years are you claiming you were unemployed, Mr. Gonzalez?
2021 through 2023.
Okay, for the sake of argument, go to those years, 21, 22, and 23, Ms. Garcia.
Okay, so for the third quarter of 21, reported with Staff Solutions, reported $2,220.66 for the third quarter of 21.
Say the number again. I didn't quite hear it in full. The number
$2,220.66.
Okay.
Okay, so then we go to the third quarter of 2021.
That's the one you just said?
It's the same quarter, but a different employer.
Oh, thank you. Okay.
He earned $3,008.80. Then same employer, the fourth quarter of 21, he earned $11,393.60. The first quarter of 22, he earned $11,235.52. The second quarter of 22, he earned $8,224.75. The third quarter of 22, he earned $10,514. The fourth quarter of 22, he earned $7,465.50. And then he changed employers. And then the fourth quarter of 22, he earned $329. And then the second quarter of, there was not a first quarter of 23, but there was a second quarter of 23 for $47. And then the third quarter of 23, he earned with a different employer $1,246.95. And then the fourth quarter of 2023, he earned $2,157.90. And then we're at the current employer that was already reported.
Okay. Okay, so there was a variance, but there was some quarters that did appear he had the ability to earn what he's earning now and did so in the prior years. Would that be your summary, Ms. Garcia?
Yes, Your Honor.
Okay, do you have any follow-up questions, Mr. Gonzalez, of Ms. Garcia?
Yeah, no, I just wanted to make sure that there was that gap between the whole year that I didn't have a job.
Well, it wasn't 2022, 2023. I see lots of low quarters. Okay, but you're back to making.
Lots of little quarters as in like $47.
Yes.
So yeah, that's obviously.
Yeah, I get it. But that's what they have. That's what they show. That's what you're trying to prove, and the records support it. Yes, but that
Well, thank
doesn't mean you're not obligated to support your child under our laws.
And I would love to if I had a job.
Thank you. I'm not going to argue with you right now. You have any more questions of Ms. Garcia?
Nah, that's it.
Ms. Solis, as a result of his questions, did that bring up any questions for you for Ms. Garcia?
No, ma'am.
Okay, and Mr. Calvano for the state, any follow-up or anything else from Ms. Garcia?
No, Your Honor.
Okay, so no further questions, and I don't have any either. So thank you for your cooperation and service here today, Ms. Garcia. You're excused.
Thank you.
Then I'll call Isabel Solis if it pleases the court.
Yes, sir.
Thank you. Ms. Solis, you're the mother of Jace Gonzalez,
Gonzalez.
is that correct? Yes.
Yes.
And do you remember entering a final decree of divorce in this case?
Yes.
And child support at that time was set at $340 a month. Is that your understanding?
Yes.
And the final decree of divorce also required that Mr. Gonzalez carry the health insurance through his employer. Is that also true?
Yes, that's correct.
And Mr. Gonzalez testified that he was unemployed for a while, so he was unable to do that. Is that correct?
That's what he was told me, but when she was reading all that, I didn't know that he had those little jobs or whatever.
Okay. Do you currently have the child covered under a health plan?
Now I do, yes.
And is that through your employer?
Yes, sir.
And do you know what the cost is just for the child to be on your health plan? Just your health plan?
I sent y'all, I forgot to make a copy for me, but I sent y'all the calculation of it, but the total was $187.50, but I don't have it written down.
And when you say total, are you meaning the medical support, dental support, and vision?
No, I'm sorry. That's the total of me and him.
Okay.
Yeah, y'all have that. I forgot the copy of it.
Okay, you presented the Attorney General with the information on your income. Is that correct?
Yes, sir.
And if I told you that what you provided us was a breakdown where just the child was $153 per paycheck, does that sound correct to you?
Yes.
And how often do you get paid?
2 times a month, every 15th and the 30th.
Okay, so you don't get paid every 2 weeks, you get paid twice a month, correct?
Yeah. Yes.
And do you also carry dental insurance for the child?
Yes, I do.
And if I told you the cost as you provided it to the Attorney General was just for the child $25.95, does that sound correct as well?
Yes.
And you're asking to be the person ordered to carry the health insurance and for reimbursement for the cost of health insurance and dental insurance as provided by the law.
Yes.
Are you also asking for a modification to guideline child support based off of whatever Mr. Gonzalez's wages are determined to be?
Yes.
You're not asking for above guidelines. You just want whatever the state guidelines are. Is that correct?
That's correct.
Do you know if Mr. Gonzalez has any other children other than Jace?
Yes, he does.
And do you know how many he has biologically born to him?
One.
One other one? Okay. Is there anything else that you would like to tell? Well, let me ask. I apologize. Was there at any time any other court order changing the child support from the $340 that was ordered in the final decree of divorce?
I'm sorry, I don't understand.
Okay, the final decree of divorce ordered child support at $340. Was there any orders after that?
No.
Did Mr. Gonzalez ever pay you anything directly that should be counted as child support?
No.
The Attorney General's claim is that Mr. Gonzalez is behind in his child support as ordered by the court in the 2019 final decree of divorce as of September 30th in the amount of $5,165.61. Does that sound correct to you?
Yes.
Do you believe that Mr. Gonzalez should be ordered to repay that obligation in addition to his child support to pay that down?
Yes.
And would you accept that additional or that repayment at $100 per month?
Yes.
I have no further questions for Ms. Solis. I would ask if there was anything that she would like to explain to the court that I have not asked her.
I'm okay. I don't have any more questions.
Okay, then, Mr. Gonzalez, you have the right of cross-examination of Ms. Solis acting as your own lawyer, so they have to be questions relevant. I don't want you to get in a fighting match about your history or your relationship. It's about the modification of the insurance and the back pay. So, Mr. Gonzalez, you have any questions for Ms. Solis?
For Miss Solis? No,
Yes,
I don't have
Miss
any
Solis,
questions for
she's
her
the-
because I know who she is. But I do have questions to the attorney who's like willing to ask all this dumb stuff that we already have set up and planned out. It's just it was irrelevant. I should have been able to object to all that. Why wasn't I able to object to that?
You did object when you were wanting to
That was-
question
no, that was
the Ms.
earlier. Then
Garcia,
he was
so you
asking
would have
more
had the
questions.
same objections, or if you had any valid legal objections at the time of
Yeah.
any testimony, you could have objected. So why didn't you object? That's on
Well,
you.
because y'all put me on mute. So
No, when you were arguing with the court or trying to talk over somebody, you were muted, but not
that was,
otherwise.
all that information was useless that he asked.
Okay, that's a
so-
final argument. That's not cross-exam questions for Ms. Solis. Do you have any cross-examination questions for Ms. Solis at this time?
Yeah, so all right, so well no, I don't have any questions for Miss for Isabel.
Okay, great. Then we can move on.
But
Hold on. Ms. Solis, you said he didn't give you any direct payments at all to make up for child support. Did he buy anything that could have been considered support for the child, especially during those time periods when he didn't have a job?
she's not where I live, so besides food.
That is not an
and-
objection. I asked a question, let her answer if you don't have an objection to it. Don't give me your side of it yet. Ms. Solis?
There are times that he misses visitation, so I don't know what he does whenever he when Jace goes over there. So I don't know.
No, I'm not
But-
talking about when, hold on. I'm not talking about things he provides for the child when he's got visits with the child and he's got
Okay.
possession of the child. I'm talking of things he might have done while the child's with you. Did he buy groceries? Did he buy clothes? Did he buy school supplies? Did he buy anything that could have been considered child support because he was doing it for the child, not necessarily, or even, well, even paying a
Okay.
bill that might have helped you provide for the child? Nothing like that?
No, ma'am.
So the only things he did was when he had the child on visits.
There was maybe one time when I went to go pick Jace up from his house, he transferred $20, but that's about it for gas. But
Well,
that
that
was-
would count, but he helped you the one time. It wasn't a birthday present, a Christmas present, something else
No.
like that, but it was considered some help and he did it voluntarily, willingly, and he gave it to you. No more than
No, ma'am.
$20 one time.
No, ma'am.
Okay. Now, do you have any follow-up
No, it was
questions,
more
for
than
Ms.
that.
Solis, Mr. Gonzalez?
It was more than that. It was like twice.
Well, then you can
3
say,
times,
isn't it
actually.
true that, and ask her a question. You got to ask questions,
But,
reply.
Yeah, no, I was just letting you know it was more than one time. It was probably like 3 times.
Why don't you
'Cause
ask her, isn't it true that, and then ask her the question so I hear her answer. That's what you're
Oh,
trying to do right now.
I don't want to do that.
Well, this is your right of cross-examination for me to hear her answer, and you're making a mistake by not doing that.
Oh.
Okay, fine. Then no more questions for Ms. Solis. Mr. Calvano, do you have any follow-up for Ms. Solis?
I do not, Judge. The
Okay,
state,
it's 10:32. We have a bunch of people for the 10:30 docket in my waiting room. So what I'm going to do is go ahead and stop your videos in just a second. I'm going to allow the state to come in and take care of those people and put them in rooms so we can start talking to them instead of them waiting for, I don't know how long for this hearing to end. So we're going to be on break. I'm going to pause my recorder. I'm going to let the YouTube continue. This is court business anyway, so I'm not going to stop that, but I will pause the recorder so we're not dealing with the Gonzalez Solis matter anymore, and I'll disappear from the screen too. And Ms. Solis, you can stop your video as well.
Okay.
And state, Ms. Awedo, you can take over for calling docket for the 10:30 cases. Okay, I officially unpaused my digital recorder. That's my official record, and we can continue after that docket call for the 10:30 cases. Mr. Calvano, where were we? We were with cross-examination of the mother. You didn't have anything further for her?
nothing further, Your Honor.
Okay, are you calling anybody else or recalling anybody else or, oh, I know what I wanted, if you don't have witnesses, just so that I can see it here in the courtroom and Mr. Gonzalez, Ms. Solis can as well, if you don't mind, what was it, the pay record and the insurance statements that you talked about, I'd like them to be screen shared so I can see them for myself and the parties can as well.
Absolutely, Your Honor.
And do I need to change the setting for the screen share? Let me look.
I don't believe so. Let me
Okay.
just get this document on the screen. And I believe it's up on the screen right now. If I can call then, or recall Miss Isabel Solis.
Yes, sir.
Miss Solis, do you see the document that I have posted up on the screen?
Yes, I do.
And can you tell me, is this the, can you tell me what this document is?
It's my health benefits for myself and for Jace.
Okay, and here it says effective 10/1/24. Did you just obtain this insurance?
Yes, sir.
And how do you know this was the cost for yourself versus the cost for Jace?
Because when I applied, I clicked just for my name before I clicked on Jace's, and I wrote down my amount, and then I clicked on Jace. I couldn't do it separate. I couldn't do Jace first, so I clicked on Jace next, and then I got the total.
Okay, so
and it subtracted from what mine would have been.
okay, so first you clicked on just a parent or just one, just yourself for insurance, and for medical insurance, the cost was $34.50.
Yes.
And then you clicked on a family plan, and the total then was $187.50, and you subtracted the $34.50 and came up with $150. Is that correct?
Yes, that's correct.
And did you also do that for dental insurance?
Yes. Yes,
And the same way you did for the medical, you clicked on yourself and the cost was $16.02, correct?
Yes, sir.
And then you clicked on family plan and the cost was $41.97, correct?
Yes, sir.
And then you subtracted 1602 from 41.97 and came up with 25.95. Is that correct?
Yes.
Did you also put Jace on a vision plan?
Yes, I did.
You understand that under the Texas law, that vision is not a requirement to be reimbursed,
Yes.
but you wanted to carry the vision plan anyway.
Yes, sir.
Okay. I have no further questions for Ms. Solis concerning this document.
Okay, well, it's still up. Mr. Gonzalez, do you have any questions for Ms. Solis about this document?
It would be good to actually see her doing it instead of it just being said that she did it. Because
I think
you know,
that's her handwriting on the form. Is
yeah,
that what
yeah.
you're
I mean,
saying?
handwriting, but for me to actually see her do it is one thing, and her actually just writing numbers down is another thing.
Well, even as a
therefore, it's
judge, I
kinda
can't get
not really
everything I
proof.
want,
It's kinda more
Mr.
like
Solis,
hearsay,
Mr. Gonzalez.
and hearsay is kind of like, it's hearsay. It's not really evidence or proof that that's actually what happened. Therefore, it can't really be admitted into this.
Anything else?
I mean, that sounds right,
If you
right?
had carried the insurance or you wanted to bring that in, that'd be one thing. But for you to be objecting to her insurance, there's no way she's going to get an insurance
I mean,
agent from the company to come to
just
court.
saying, like, there's no actual proof that that's what the numbers were. This is just going by.
I can't see it very well, Mr. Colvin. I don't know if you can enlarge it or not, but the light, yeah, there you go. The part on the left, that's not her handwriting. What does it say? Benefit plan, that's the basic life with, what is it?
With both her and Jace.
The 187.50. So the proof is that it costs for both that amount. And we're taking, well, this is supposed to be sworn testimony that she couldn't print anything else. So she figured out, you don't have the piece of paper that says yours was 34.50, Ms. Solis.
No, ma'am, I don't.
And here on a stack of Bibles, you'd be telling me that you're not making that $30.
I promise. I am not lying about it.
Okay,
Regardless of
but
what the
we have
form
proof
says.
that it's the amount of
That's that proof.
187.50 for the total. Now for the medical, I'm seeing on the screen share go further down again, on the medical. There you go. Or the dental rather. The total is a 41.97 number that she's testified to.
That's the dental high plan. Why did she pick the dental high plan?
I guess that's a question. Ms. Solis, can you answer that?
There was only 2 plans and they're only like $1 or 2 difference. They weren't even, it wasn't even a.
So now it's likes instead of actually being.
If you want to provide it, you want to bring proof of it, fine. This is what she decided to get, and that's what we're questioning.
How am I supposed to get proof of it?
No, if you wanted to provide the insurers or you were ordered to provide the
Oh, I
insurers,
mean,
you
I would
didn't
love
do
to
it.
if
So
I
now you're
had it.
stuck with her evidence here today and her sworn testimony. So,
Well,
Ms. Solis,
again,
the difference between the plan you picked and the plan that was still there, that might have been a little cheaper, is not but a few dollars. Is that what you said?
Yes, ma'am.
That was for the
It was
dental.
only a couple dollars down.
Okay, but it did, his is still higher than yours and it's only a few dollars difference, but you made it less because of he's not supposed to cover you, just the child. So
Yes, ma'am.
what you're telling me, child's portion is $25.95.
Yes, ma'am.
Okay. And then vision,
Um,
well, we're not gonna be able to help you with vision, but that's only a few dollars as well. It's a total
That's fine.
$2.71.
And I am paying these two times a month. So like each paycheck they're taking it out.
That's the total monthly amount?
The 180, yes, the 187 they're
Yes.
taking out. The 153 for Jace, the 153 they've taken out for each paycheck, and then they're taking out the 25.95 for each paycheck.
That's different from what I heard earlier. Mr. Kalana, you want to address that or clarify that?
Yes, Miss Solis, the amounts that were just shown on the screen, those are those are not monthly costs. Those were costs per paycheck. Is that correct?
Yes, that's correct.
Does it say
And-
it on the piece of paper? I wasn't looking for that part.
It,
See what I'm
it
saying?
does say semi payroll.
But why wouldn't it say that it's monthly or bi-monthly? Let's see.
It's a little bit down. Right there, total semi-monthly payment, payroll deduction.
Okay, well, the state didn't get that either when we were testifying, because now you're saying you want double?
No, I'm just saying that, I'm just telling you that's what, I'm getting charged for. I mean, they're taking it out for each paycheck. I thought I had told Mr. Cavano, right?
That's correct.
When I had got paid, like I got paid and it was times 2.
And she did, Your Honor, and that was the purpose in me asking her very specifically why she or how she got paid.
Yeah.
When I asked her that she didn't get paid, every 2 weeks, got paid on a semi-monthly basis.
I get paid 15th and the 30th.
Because those costs came out of each paycheck, and then they would need to be combined for a total monthly amount.
Yeah. Well, I hadn't heard that part yet, so I was trying to clarify what I just saw and heard, and especially for Mr. Gonzalez's sake. So what are you saying, Mr. Calavano, or what is Ms. Solis saying about request for reimbursement?
So the cost for the medical support to Miss Solis on a monthly basis for just the child Jace, based off of her testimony, is $306 per month. The cost for the dental support just for Jace, as Miss Solis has testified, is $51.90 per month, $51.90 per month.
Okay. And so that's the amount you're asking for as reimbursement, Ms. Solis?
Yes, ma'am.
Okay. Any follow-up questions of Ms. Solis, Mr. Gonzalez?
Yeah. Why do you think it's fair that I get reimbursed back for all the times that I've been paying? Or should I get reimbursed back for all the times I paid health insurance for Jace? Because if that's what you're doing, that's what I should be able to do. And it's 50%. So you have more rights than I do.
I have
So-
him. I'm
Right.
taking care of him
Okay,
and
right.
taking him to the doctor and
Did you when you decided to take my days away from me without any prior consent or anything, you think that was fair? Do you
When
think
I-
I wanted my days removed?
when have I taken your days away?
We had 15 days each other. We had a fair 15 days, and then I fed him nuggets, and then you took them away, and then you took them away from me, more of my days. So do you think that's fair?
First of all, that was when he was 5 years old.
Okay,
5 or
so
6
it's been
years
4
old.
years that you took away my days.
And secondly, I had explained to you that he had a stomach virus
Doesn't matter.
and what the doctor had told me. And I sent him to you after he was feeling a little better, but I had told you his diet and
Right.
you
Okay.
did not follow through.
Right.
And so that he got sick again the afterwards. And then that's
did
when I had told you it was for his best interest so that he can feel better, so he can be completely healed. He's going
Right.
to make that.
So you're not feeding him chicken nuggets. Is that what you're saying?
That was that time when he had the stomach
It's the whole
virus.
time,
Hey,
buddy. It's the
you
whole
know-
time.
Judge, I'm going to object to this line of
Gonzalez.
questioning.
Of course you are.
Well, Mr. Gonzalez, what you're trying to get into is stuff that I can't fix, that I cannot
Yeah,
modify, that I
fix it.
cannot address. I let it go for a little bit to see if it gets it off your chest and you get to tell a judge about it and how unfair it is. Fine, we can move on with the child support part.
So
But
you
this
understand
is
that I'm
not
supposed to have
a
days-
modification of visits or makeup of visits or contempt of visits or any of
So you
that.
understand
But I
that.
will ask Ms. Solis, is there anything in that divorce decree that says that you all get 50-50 split possession?
It
No.
was already 50-50.
No.
Yes, there is. Yes, there is.
Where does it
Divorce
say
decree.
50-50? It does not say 50-50 anywhere. I
We
don't,
had 15 days per person.
No,
It says
you're
I don't have that.
mistaking me. You're mistaking Jace with Saban.
No, I'm not.
Yes, you are. You
Okay,
No,
stop,
I
stop.
am.
Ms. Solis, you can stop. Mr. Calvan, do you have the divorce decree on hand? And can you review the conservatorship sections or the possession sections to see if it has anything about 50-50?
Yes, Judge, I will.
No, so I'm lying, is what you're saying.
Look, there's a piece of paper that's called divorce decree. It's got 4 corners. Anything that's in it is relevant, and I get to review that. That's what I'm trying to do,
Well-
to see if you have an argument on any of this, Mr. Gonzalez. But
Yeah.
if there's a divorce decree that gives her custody and you visits, and it's the standard visits, then that is
Yeah.
not a 50-50 split
Well,
that you're trying to
when
argue.
when we went to court, we had our own paper that was already.
Unless it
that was
got
approved.
attached to the divorce
That was-
decree
yes.
and says it's specific to you all
Yes.
in this case, it doesn't count, that piece of paper.
That's exactly what it does. And that's exactly what it is.
And you're telling
And
me
the
you
judge-
read your divorce decree and under duress you signed it and it gave you 50-50?
Yes.
Okay, let me see
judge-
from Mr. Calvano, and I'll ask Mr.
approved-
Calvano to screen share the decree if I have to, but I don't want to do that. You're an officer of the court, Mr. Calvano, so whatever
The
you're
judge
reading off of
approved
will
our
be helpful to me.
50-50.
You want me to share it, Corey?
Um,
How are y'all not? I hope y'all read all this stuff. That's what I'm saying. Like, I don't know, but my son Saban, he knows. And he
Mr.
was there
Gonzalez,
whenever
it's
we
not
took him
about
out.
what the child knows or what you think
it
you know.
does.
It's now
Yes, it
about
is.
the 4
Yes, it is.
corners of the divorce decree, and I'm giving Mr. Calvano the time to review it and tell me what it says
That's
so
cool,
that
me
I can
too.
understand if you're right or you're not right.
I am right.
I'm
I
not
am
taking
lying.
your word for it. There's a piece of paper that supersedes whatever you think you know, whatever your memory thinks you know.
Y'all should have read all this before. I don't know why y'all didn't read all this.
Mr. Gonzalez, you don't get to put on this case, the state is, and you've raised issues, so I'm trying to resolve them for my benefit. I was not a part of your negotiations. I didn't hear everything that happened back there. The state does their best, but they have thousands of cases, not just yours, so they don't get to read everything as precisely as they might have had they been a hired lawyer. You had the right to hire a lawyer, bring your case, you didn't. So now
I
you're
don't even
stuck
do that.
with what we have to do here. And it's in my interest to find out whether I think you're telling me the truth or not, and whether that divorce decree supports it or not. So it's not your time to talk anymore. I'm gonna let Mr. Calvano figure it out and tell me.
Thank you, Your Honor. Your Honor, in my own defense, this is not a modification of possession. There's no reason for the Attorney General to read a possession order and a divorce decree when that is not on the table. Nevertheless, on page 26 of 29 of the divorce decree, it is a standard possession order. Parent A is named as Isabel Gonzalez. Parent B is Gerald Gonzalez. It does have a mutual agreement section where the parties can deviate from the standard possession order if it's by mutual agreement. The rest of it has the weekend provisions at the time the child for parent B on the first, third, and fifth Friday each month at the time the child's school is regularly dismissed and ending at 6 p.m. the following Sunday. It has weekends extended by a holiday at the time the child's school is regularly dismissed, and on Thursdays at the time the child's school is regularly dismissed, in spring break. I don't see any provisions that have anything to do with 50-50, Your Honor.
Okay.
Yeah, so it was 50-50, and then she unmutually agreed by herself to take away my days, and yeah. So if she couldn't do that, she violated the court. There you go.
Is there a piece of paper that you filed with the court that says you had an agreement at a certain time and then that you revoked it, Ms. Solis? Anything additional to
Oh man, the only thing that I signed for was the standard court order. The mutual agreement that he's talking about was before, when we got it notarized, before the court order, before all that stuff happened. And we went to court, Gerald, I am talking. When we went to court, then that's when the divorce decree and then the standard court order. So in my knowledge, I would think that the court order overpowers anything that has to do with before that.
No,
Okay.
But
thank
the
you.
court and the judge signed it and notarized it or
And you
stamped.
didn't do a new agreement after that divorce decree to reinstitute the 50-50?
No, ma'am, we did not.
yeah,
The
it was
only-
attached
Talk
with
about
it.
it? Did you remember talking about it, at least that you're going to the divorce decree and not that piece of paper you did before the divorce? Talk about it with Mr. Gonzalez. and sort it out.
every once in a while, I don't even know why he's complaining right now, because every once in a while, when Jason's sick one day, I let him have my weekend and I let him go to him on those days, because I think about how Jace misses. So like we work it out every once in a while, like that, like for
Make
Jace.
visits? Okay. But you never went back to the 15 days or whatever, 15 days each that Mr. Gonzalez says happened before? You didn't
I
go back
don't
to
even
that
remember
happen?
the 15 days. He's thinking of, I really don't even remember the 15 days, but everything was the same exact thing
Okay.
as it is.
Your divorce decree doesn't have an attachment that includes that 15-15 split?
It does not, Your Honor.
State says it doesn't. Yours doesn't either. Miss Solis, your copy of it?
No, ma'am.
Okay,
It should
thank
have came with it because the judge.
Mr. Gonzalez,
stapled
unless you
with
have a
it.
piece of paper that has it as an official page to a divorce decree and it's a certified copy of it, I can't take your word for it. The state has a copy of the official version, so that's what I'm going on. So I've given the visitation issue plenty of discussion now, Mr. Gonzalez, and whether you like it or not is no longer relevant. Okay. So
Effective
we did the
12
insurance
until
cost, we did the
until
FINA. Mr. Calvano, can you screen share the financial activity report, the pay record that shows the arrears?
Absolutely, Judge. Judge,
Okay,
on the
I'll screen
screen,
share.
you'll see the financial activity report. This is from the beginning of the obligation in 2019. This is the official activity report printed today, just a few moments ago. And
It's dated October 8th today, and then how many pages of the pay record?
it is 7 pages long.
Okay. And we saw that child support of 340 started March 1st, 2019. We see payments along the way. And if you'll get to the bottom of page 7, I guess, and you were asking for arrears findings as of September 30th. Do I remember that right?
That's correct, Judge. And that is right here, the third line up from the bottom. And
Okay.
that number, great, need glasses, $5,165.61.
516561 as of September 30th. I see that. Do you see that, Mr. Gonzalez? I have an arrow right on the, or I don't know if you can see my arrow. You can see the state's arrow. Mr. Gonzalez, you see the number 5165 and 61 cents?
Yeah,
And all the way on the other side is as of September 30th. That's where that number comes from. So we're not including October, what was due and what's already been paid. It goes only as of September 30th. Do you have any dispute with that number, sir?
oh yeah, you already know.
What's your dispute?
The whole year and a half I didn't have income.
Okay,
got
you're
took
saying
out.
your child support should have just automatically stopped no matter whether you had a job or not.
Right, because you cannot
Okay,
take
thank you,
money
sir.
out of zero. Yes.
I
The
get your
math-
argument.
The math
Thank
makes
you.
sense. Thank you.
Anything else? I think I've got the information I need for the record, Mr. Calvano. Anything else you need to present?
So that should like take away half of what I owe at least, because I didn't work. So
Okay,
it's
let's
not
go
that I
to
wasn't
you.
willing to pay.
You think it's
It's
fair
just
to
that-
stop child support because you weren't able to,
Yes,
you
because you
weren't able
cannot
to earn
take
any money?
zero-
So she had
you
to pay
cannot take-
100% of everything herself, even if she had a job or didn't have a job? That's what you're saying?
That would be a responsible parent. Yeah.
Responsible parent owns up to what he owes and catches up. And you
Right, that's what I'm
do
trying
what you
to do.
could
I'm
at the
sorry that
time.
jobs couldn't hire me. It's my fault that jobs didn't hire me.
No, I'm not saying it's
Okay,
anybody's
that's what
fault.
you're
I'm
saying.
saying you still
Exactly.
had a
Because I've
legal
been paying this whole
obligation to
time.
support your child, whether or not you had a
Right.
job. So now
And
you're
I've
just
been
making it
paying-
up.
And when I got a job, that's what I've been doing, right? So if I didn't have a job, obviously I couldn't do it.
Do you have any other, you said you shouldn't pay because you didn't have a job.
Right. And because like when I did have a job, I was paying it.
Okay. What else are, what arguments you making? I'm gonna let him go first,
So
Mr. Pisano.
go ahead and take that
Okay.
off. And then we'll talk about the real number that I owe, and then we'll keep going from there.
Well, thank you for doing my job, sir, but you already gave me an argument on taking off half of the arrears. That's your position. Your argument for child support, why it should be modified, or actually, I think you're arguing it shouldn't be modified, but I haven't heard any numbers yet. Do you want to hear the
Yeah.
numbers from the state before you make an argument, Mr. Gonzalez?
Yeah, because
Well,
we already had a signed thingy by the court or whatever for that amount, and that's what it should stay. If we're not going to follow all of it, we shouldn't. Then case
you have
closed.
a signed thingy for that amount and it should stay forever. That's what you're saying?
That's right. Because
Okay,
just
thank you. I
just
get your
everything
argument
else
on
in
that. So you
just like
addressed
everything else in
the
that document.
arrears, you addressed the modification, and what about she said you only paid $20 toward the arrears. Do you have
Yeah.
any argument otherwise?
I mean, why would I do documents?
Well, I didn't hear any testimony either about what you think you did for the child while you
Well,
didn't have a job.
I fed him. I did what I needed to do when I could. You know what I mean? Like,
And that
I
was
love my
when you
kid.
had visitation with him, right?
Right. Well, because
You weren't
you want me to
feeding
go to
him when
her
he was
house?
with mom.
Do you want me to go to her house? And she has a husband,
No,
so
I
like,
expect if you could have $20 here and there and you give them to her to help support the
Right.
child, yeah, I would give you credit for that.
yeah, if I had $20 here and there, yeah.
But she
But-
said you only gave her one $20 payment at any time. So are you saying you did more? When the
Am I
child was
saying
with her?
I did when the child what?
When the child was with mom, not on your visitation weekends, when the child was with mom
It
and you
doesn't matter
weren't
when, to be
earning a
honest.
living, what did you do for the child?
I loved him. I supported him. I gave him everything that he needs.
Does it have a dollar amount?
Does that need a dollar amount? Why does it need a dollar amount?
Because we're talking about numbers, how much you owe.
Right. So, but that's to the court, you know what I mean? Like child support, yeah. But like, I didn't have a job, so
I can consider anything you did for the child, and this is the one time I can do it and never again. She said you only helped her with $20 one time and it was gas
Yeah.
money or whatever.
I mean,
So did you
it was
do
probably more
anything
than
else
that.
that was of monetary value that she benefited from? Like, did you buy clothes? Did you
You know, I
give
have
her
no
something else?
memory. I don't
Grocery?
remember. Like, I don't try to like keep money isn't a priority to
Well,
my
it is
son.
here today. You're
Isn't
making
it
it a
money?
real priority
Which is
today
y'all's
that you
problem,
shouldn't owe it.
actually. Like, which is y'all's fault, really. Like, y'all think money like shows support and love for a kid, and that's where y'all are wrong.
No, the law
Yes, y'all
says
do,
you
'cause that's
support the
certified.
kid, not because I say so. It's I'm following the law. And the law says you have an obligation to pay a certain amount, whether or
Right,
not you
so-
have it that month, it adds up with interest and then you pay it off later when you can.
So,
That's what this is about.
Me loving my son, you know, I don't keep tabs on what I pay for my son because I love my son. So
But it didn't help her pay her bills while you weren't employed, so she had to cover 100%.
So again, and that's what a responsible parent's supposed to do is pay their own bills, not get help from somebody else to do it.
Well, this is your bill that you should have been paying or need to
Well,
pay now. That's what a responsible parent also does, catches up when he doesn't pay.
My bill, this isn't for bill, this is for child support. This is for my son. I'm hoping.
Okay, fine. So what do you think, Mr. Let me go to Mr. Well, it's the arrears payment, the modification, and the insurance. Insurance, what do you, are you disagreeing that she should carry the insurance? And what's your argument on the insurance?
I don't care. I don't care about who carries the insurance because I don't mind. I always once I have insurance, I always put my kids on insurance. But I don't have a job to have insurance right now. So until then,
you don't have a job right now, even though I heard you have an income right now?
I have a job, but it doesn't provide insurance right now until I get hired on to the company. So until then, just like I've always been doing this whole time, you know, it is what it is. So I'm just saying if she's going to get reimbursement for any of that, I should get reimbursed for the time that I spent with the child on medical support.
No, because you were court
What?
ordered to do, you were
What?
court ordered to do that without
That's not fair.
reimbursement. It's part of your obligation. The law
that doesn't
doesn't
sound
support
fair.
now her paying you back for the times you did because you were obligated to provide it.
Right. So that's
So
what she's. So
any
she's
other
putting
argument,
that-
Mr. Gonzalez? Any other
so
argument?
That doesn't seem fair to the court.
Then you argue it to somebody who can change the laws on that,
It
not
is,
me, because I'm
y'all.
just trying to follow the law.
Is it
So you're
fair or not?
saying, I get your argument. You don't have to repeat it. So you want her to pay you, but you don't have any pleadings for that, correct? You didn't put it in
Wow.
writing and put her
How
on
do I
notice
do
for
that?
today?
How do I do that? Nobody's told me how to do anything.
Well, then you didn't seek legal advice, obviously, and you didn't use your common sense. You can write a letter to the court and ask for whatever you want, and you didn't do that, correct?
Well, yeah, no, I didn't because
Okay, thank
I
you.
already had the case set up.
So for the
So
payments, if you owe back pay, how much should you pay every month? They're asking for $150, no, $100 a month. I heard that right, Mr. Colonna?
That's correct, Your Honor.
What was the back pay should be, Mr. Gonzalez?
the back pay for what?
For whatever you owe in arrears payments for not paying your child support.
I'm already paying it.
Your past child support, arrears are
did
the
we take
past.
How much did we take off? Because I know
No,
I
we
increased
didn't
it.
do anything. You're asking me to, I get to decide. So I'm asking what your position
Well,
is. We do
my
not do
position
anything
is-
together. I am gonna rule on your case after I hear all your arguments, so I'm giving you the chance. What should the arrears payment be on whatever number I order?
Well, we should really get the main number first.
No, we cannot do anything. You get to tell me what you want, and I hear everybody, and then I decide. I'm
Okay,
last. I say the last
well,
word rules.
I'm already struggling as it is. Being a solo income person. So I don't know, $10, $20.
Mr. Colonna, does he have an obligation that you're aware of on the other child?
Not that I'm aware
No,
of,
I don't-
Judge.
You don't have a court order for the other child, Mr. Gonzalez?
No, because I have 50-50 for my child.
You have what?
I have 50-50 joint custody with my other child. I don't
Okay,
pay
fine.
child support
I'm
because-
I'm just asking if I should consider something else, and you just told me.
So
How old is
I
the
have
other
another kid.
child? How old
He's
is your other
15.
child?
He's 15. He's been there. He's seen me cry for my kid, my son Jace.
Your child
He
is
knows-
15. You answered my question.
knows
Thank you,
the
sir.
trauma that I've
The
been
child's input on this case is not relevant, that other child. So, okay. Mr. Calvano, let me go to you. Let's let you make the argument for the state at this late date after Mr. Gonzalez has had his chance.
Thank you, Judge.
Who keeps muting me? Stop muting me, please.
Well, quit talking, Mr. Gonzalez. That's what's happening. You're interrupting all
No,
over the
you
place. So
see,
you
I
need to
should be
stop
able to have-
talking. It's
I should
Mr.
be able to
Calvano's turn. I get to control this. You don't get to do this. This is my courtroom, sir. I'm not in your living room. You are in my courtroom with rules. Mr. Calvano, next, your closing argument, Mr. Calvano.
Thank you, Your Honor. Your Honor, the testimony by the child support officer was that Mr. Gonzalez earns, based on the last quarter of income on full employment, it would be a monthly amount. It would be a monthly amount of $3,854 per month. That's a gross number. The medical support that's requested reimbursement in this case is $306. Even if the court orders finds that a gross income is slightly less than that because we don't have a longevity of income, the 9% cap by law on what reimbursement on medical support should be would be $346 based off of that gross. So that could even come down a little bit. So the state believes that $306 reimbursement is appropriate, and Mr. Gonzalez would get credit against his gross income for figuring child support on that. The 1.5% based off of a gross of $3,854 is $57.81. So the dental support requested by Ms. Solis also falls under the guidelines or the law of 1.5% of the gross income, because it would only be $51.90 that's being requested as a reimbursement. There is no request for a vision reimbursement. Ms. Solis is just going to have to pay that on her own. That would come up with an adjusted monthly net resource of $2,905.02. We would use 17.5%. Since Mr. Gonzalez does have another child, and guideline child support then would be $508. The state is requesting a judgment against Mr. Gonzalez for the arrearages. As of September 30th, the number is $5,165.61. I do believe Ms. Solis has testified that Mr. Gonzalez did pay $20, and giving him credit for that, then the judgment would be for $5,145.61. The state would not have a problem with moving the repayment down a little bit. The interest on the amount currently would be right around $25 per month. So in one of the ways that the state typically tries to determine what a repayment is we take the interest, add $50 so that you're paying down some principal. And in this case, that would make it $75. If Your Honor wanted to go down even a little bit more, the state would not object to a $50 reimbursement payment, although I don't know if Ms. Solis would object to that. The state is asking that these modifications do take place as of November 1st. And the repayments begin on November 1st as well.
I didn't hear anything about it, but I have to ask, any non-disclosure issues or court costs?
There is no non-disclosure issues on Ms. Solis's behalf, Judge. I did not, wasn't able to ask Mr. Gonzalez about them. And the only person that the state can request court costs from is Mr. Gonzalez.
He didn't want to negotiate.
You didn't want to negotiate, Mr. Colvano?
No, he didn't. Yeah, he didn't want to negotiate. I was willing to negotiate. He just wasn't trying to hear it.
Judge, that's a flat out lie.
It's
I
not.
asked him specifically if he wanted to negotiate or go in front of the judge, and he said he did not want to negotiate. Therefore, we brought the case
that's not true.
directly to Your Honor.
We have it on court order. Record.
There's no record till I started the case. And once I start the case, I'm involved, and it's not a negotiation, it's a trial. So I've heard two versions. Mr. Calvano, you're an officer of the court. I can't believe you would be making anything up.
Yeah, no, I told him I
was
was
Ms. Solis in the room when any of this happened, Mr. Calvano, or you talked to
No,
her?
Judge. We were in separate breakout rooms.
Okay.
Yeah, no, I told him I'll
Your Honor-
negotiate, but I'll negotiate for 0%. And then he said, I don't want to hear.
That's not a negotiation, sir. That's like a whatever, but that's not
you know what I
negotiating when
mean.
you say
You know
it's
what I'm
my
saying.
terms or no terms. That's not a negotiation. They're not going to sit there and waste their time. They're going to bring you straight to me. So I
You
get
know
it.
what I mean.
I get it. I get it. And I'm not calling
Yeah.
anybody liars, but I get it. Okay, Ms. Solis, is there anything you heard from Mr. Calvano with the state's recommendations that you don't agree with?
No, ma'am, everything's fine.
Okay, I've heard what you've had to say. I'm not going to go over it again. I know what you want. You want as little as possible and as much as you can get, and it's not a consent, and you want contracts, and you want this, and you want that, and you want to be a part of it. And
Yeah, because
you have cooperated, you have participated, but it doesn't work that way. I have
All right,
jurisdiction over you. Okay, I'm going to let you say one last sentence because now it's going to be my turn and I'm going to rule. So what is it you have to say before I rule, Mr. Gonzalez, that you have to keep interrupting me with?
so what I want to say is I'm just as important as the mother. and I have just the same amount of rights as the mother. And there should be no reason why this court can't be completely even. I love my kids. I want my kids. I'm supposed to have 50-50 with my kids. So there's no reason, absolutely no reason why I should be losing and she's gaining, and it's not, and it's unfair otherwise. So there should be some way to negotiate so where either we're both paying each other child support or something, because she has no rights above me. She's just as equal as I am, and I love my kids just as much as she does. So it needs to be fair, and until it's fair, then this is an unfair trial. And secondly, I just want to say also that it was child support was redeemed unconstitutional by the Supreme Court ruling for the violation of separation of powers required by the Constitution, Article 31,
Show
Section
me
1.
the paper, Mr.
Further-
Gonzalez. There's no way you can show me anything like that. Your word on legal matters does not count. You're not a lawyer. You don't even know how you
I'm
properly
pro
hear.
se. What are you talking about? I am a lawyer. Furthermore, the child support actions are unconstitutional.
Give me
due
your
to-
bar number. Give me your bar number right now if you're a
due
lawyer.
to,
Texas bar license number.
due to the lack of clause and wait, what's it? Lack of
I don't know who you talked to, but
So-
they gave you a bunch of baloney, sir.
no, it's not baloney.
You have a
It's
law
not
license.
baloney.
Give me the bar number
It's
right now.
unconstitutional. It is unconstitutional. Your actions are unconstitutional for no probable cause.
This isn't a criminal court, sir. This is
It
not a
doesn't
criminal
matter.
court. It's a civil matter.
Exactly. So
Are you
there was
done
no-
with the arguments on this specific case? I don't want to hear any more constitutional or
Again,
unconstitutional
it's
arguments.
unconstitutional.
If you don't have a brief and you don't have a law license, I'm not listening to it.
But-
Anything else
but
on the
that's what
facts,
pro
Mr.
se-
Gonzalez?
That's what pro se is. Pro se is you get to be your own attorney. So I don't need to have the bar license to do that.
You told me
And
you
what
were a
you're-
lawyer, and that pro se does not mean you're a lawyer. You can
What-
act
what
like
is
a
it?
lawyer, but not a
Okay,
lawyer. You're
right.
not licensed.
So I'm
And that's why
acting
you're
as
making
one.
arguments that make no sense.
I'm
You
acting
didn't
as
go to
one
law
and
school.
saying that
Okay,
it's
Mr. Gonzalez, any
unconstitutional.
more argument on the
So-
facts? Because I'm ready to rule, sir.
These are the facts. It's unconstitutional what you're doing.
That's a legal argument, and the
And
court
there needs to-
disagrees with you, sir. Okay,
But
I'm
that's-
done.
but
I'm
that's
done.
by the
This is
Supreme
the
Court.
court's ruling. It's my turn, Mr. Gonzalez. You've had plenty of argument. It
That's
is
the Supreme
now
Court. Well,
an hour and 21 minutes. It's my turn. This is what I'm going to do. This is what I've
Sure.
heard. This is what I'm going to. No more, Mr. Gonzalez. Quit. Stop. Stop. You're going to stop. You're not going to talk anymore. It's my turn.
well, what are you gonna do?
No, it's my turn. I told you. I gave you plenty of time. You've told me. You're repeating yourself now, and now I'm repeating myself. So stop.
You need to solve this
The
issue.
ruling is, this is a final order. I'm granting the
Unconsti-
modification and confirmation, but these will be the terms that the court thinks is fair, right, and just. And if you don't agree with me, either of you or any three of you, y'all can take it to a higher court to appeal me, and I'll give you that in a minute at the end of this. So on the confirmation of arrears, you don't get how the law works, and you're not going to get it because it's not in your interest, and you can argue all day long. So go hire a lawyer, go appeal me, and go argue to a higher court that I'm wrong on the law. So
It's
as far as arrears, you owe the arrears minus the $20 that she testified to. So I will grant a judgment of $5,145.61 that is owed by dad to mom as of September 30th, 2024. The payments on that judgment shall be
Objection.
you
Unconstitutional.
can object to my ruling. You don't have the time or the space to argue anymore, Mr. Gonzalez. I'm done. I heard your argument. I can repeat your argument better than you can, but I am now ruling. It's the court's turn, so you can stop the muting and unmuting, sir. Stop.
I can.
No, you're not talking anymore. The
I
arrears
should be able
payment
to
is going to be
object.
$75 a month starting November 1st. On the issue of modification,
Object.
this is my courtroom. I get to talk. I'm not going to yell anymore. You're not talking anymore, Mr. Gonzalez. I'm going to finish my ruling. So you can hear all of it. You can write it down. You can wait for the court order to come through and you can appeal me. There's nothing else that you can argue, that you can repeat, that you can reopen testimony and testify to, or evidence you can, there's none. It's done. I've heard it all. I'm making my ruling. You heard me say you owe $5,145.61 as of September 30th. You're going to pay that off at $75 a month. That's on the confirmation of arrears. On the issue of modification of child support and medical support, I will find that the circumstances have changed. That mother now needs to provide the insurance, and I will grant that. So mother provides the medical insurance and the dental insurance. The reimbursement for that, at this point, I don't agree with you, ma'am, that it should be a full 100% of the 9%. I'm going to do 4.5%, which is what we routinely use, that you got a good insurance plan and it costs more for the child. Well, you're going to have to cover half of it. He'll cover the other half. So the original numbers that I heard is what I'm going to put in the order and remind me what they were. Let's see.
153 for medical support, Judge.
Objection to all that.
153 for medical support starting November 1st, and for dental support, what was that number again, Mr. Calvano?
$25 and some change, but rounded to 25.
$25 a month, also starting November 1st. So, and so that if you do the math on adjusted net with those numbers, what is the 17.5% yield, Mr. Calvano? Can you do that
Okay.
for me?
Yes, Your Honor.
So you get a,
In that case, Judge, the adjusted net would be $3,084. And 17.5% of that is $539.70, or $539.
okay, I'll order $539 a month. She gets a few extra dollars of child support, but he pays more than that off of the medical, or less than that off the medical and dental support originally requested. So $539 a month starting November 1st for child support. I don't find that there's a 50-50 split, so that he shouldn't have to pay, so that I should have to vary from the guidelines. So I am granting guidelines with 4.5% for insurance. And then on the issues of non-disclosure, I didn't hear, did you even plead them, Mr. Calvano? You didn't plead for any non-disclosure?
We didn't even plead for it, Judge, and it was not
Okay.
requested by Ms. Solis.
So then there's no non-disclosure issues to be had in this order. And on court costs, I'm gonna do you a favor, even though whatever, I'm just gonna do you a favor. You have money, you send it to child support, I'm gonna waive the court costs. He gets to win one small thing, and on the issue in insurance, I get 4.5% instead of 9%. So I think that's what's fair. I think that's what the law supports. I think that's what the facts indicate I should do. And now, if anybody does not agree with me, you can appeal me. The right of appeal, there's a one-page document that can be attached to the back of the order, Mr. Calvano.
Correct, Your Honor.
So you'll put that on there, the de novo rights of appeal, but basically, this is the way it works, is that I've ruled today, I've done a final order, the state's gonna draft it, put it in writing, send it to you by email, so you get to look at it first. If you agree with it, fine, you can sign it. Even if you don't agree with it, you can sign it as to form only. That doesn't mean you agree with the substance, so that you can still appeal me. And even if you signed it, you could still appeal me. But once you sign it, you don't sign it. Once I sign it, from that day forward, you have 3 days notice, or you have 3 days deadline to file a notice of appeal. So whenever you get the signed copy, it comes by DocuSign, it comes electronically, then your 3 days start running, and it would be 3 business days. The Monday through Fridays, the Saturdays and Sundays don't count. So at that point, within 3 days, you file a written notice of appeal. It has to be in writing. You have to tell the court you're appealing. It's called a de novo appeal, and you put it in writing. You object to whatever you think the errors I made. You file it with the district clerk's office. You send copies to the other 2 parties. So Ms. Solis, you appeal me, you send it to Mr. Calvano and Mr. Gonzalez. Mr. Gonzalez, if you appeal me, you send it to Ms. Solis and Mr. Calvano. You got email addresses, you can send it put them on notice, and then you still haven't done your job by filing the request for an appeal. You have to call the district clerk's office and get a court date within 30 days from when you filed. So the appellate court, which would be the district judge level, the elected district judge, can hear the case brand new and see what I did and see if they agree with me or not. So that's your appeal rights. If you don't do that, then you're stuck with this order anyway. Right now, you're stuck with it because it is my order, and unless and until another court overturns it, it stays my order.
Supreme Court.
So, Mr. Calvano, do you need anything from the parties? You have their information that you can disclose in the record, and including emails for sending the copy of the proposed order?
Let me just confirm, Judge, but I
Well,
believe
don't
so.
do it on don't do it on live stream.
No. I'll just
Confirm on
look.
your own. I assume they got notices with the reset orders that got sent and what have you besides court notice.
Yeah, we have emails, Judge.
Okay, so check your emails. That's where the information is going to come, this order that they're going to ask you to review and sign. And why don't you just go ahead and put as to form only for Mr. Gonzalez. So if he bothers to sign it, I get it quicker, but it says as to form only, which means you do not agree to the substance of it. Legally, that's what it means. And if you sign it, fine, it comes to me quicker and your appeal starts. Or if you don't sign it, and you have that right too, Mr. Gonzalez or Ms. Solis, you don't bother to sign it. I give the state 1 week from today to turn it in. So it's going to happen. I'm going to sign it with or without you. I'm rendering the order because I've had a hearing and it's my order anyway. So I'm rendering the order, and I get to sign it whether or not y'all bother to sign it ahead of time or review it and sign it. Anything else I need to tell these parties, Mr. Calvano?
No, Your Honor.
You know, wouldn't mind having you put the Children's Bill of Rights at the end of it. So it's a professional's versions of what parents should do and not do, and how you should treat each other and talk to the child, or what you tell and don't tell the child. So I think it's important enough to put in there the Children's Bill of Rights.
No problem.
I don't need you to put in there that his verbal requests that all of this is unconstitutional, including my court, including the law,
it is.
including this, including that. He thinks everything can be objected to and can be found unconstitutional. Like, I'm not going to say it. I'm not going to put it in writing, Mr. Calvano.
Minnesota law,
But
Supreme Court.
Mr. Gonzalez, you talk to a lawyer if you think I did it all wrong. You go
But
get
you
your
already
own
know you
legal
did.
advice, or you go appeal me and go to a
You know
higher
you did it
court
wrong.
and you tell it there. I'm done. Thank you, folks, for being here.
It was the
That
Supreme
concludes
Court
this
ruling in
hearing.
Minnesota
All
that
I
gets
need
me.
you to do now is leave my
Supreme Court is over you
courtroom
guys.
and check your emails from Texas Office of the Attorney General. I'm gonna actually remove you all so I can get this done quicker. Thank you, Ms. Solis. You're gone.
I don't think
Thank you,
can
Mr.
take us off. I
Gonzalez.
think
You're
you can
gone.
if you leave first, you lose. Right?
You're
Because-
gone. I'm done. I ruled. That's over. It's done. I sent her out first so you wouldn't claim I was still talking to
be-
her. So I'm not talking to you either. I'm gonna remove you.
Let it be on record. You
Oh, I can't,
supposed
for
to
some
do.
reason, it doesn't let me remove him.
Let it be on
somebody know how to
record.
fix that?
That's unconstitutional what you did, and that
Judge, if you want to make me host, maybe I can figure it out.
Oh, I think I just figured it out. I'll do that in just a minute. I'm removing you, Mr. Gonzalez. This hearing was over a minute ago.
unconstitutional.
This is done. You're done. Bye. Thank you, Mr. Calvano. That'll conclude this hearing. Let me stop my recordings and we'll move on to the next.